Section 88. In this lecture, we will discuss of causing miscarriage, that is, offences against the woman. Section 82, Section 88 to Section 92 of the Bharatiya Nyaya Samhita deals with the offences against the woman, particularly of causing miscarriage, etc. Section 88 to 22 of the Bharatiya Nyaya Samhita deals with comprehensive with offences relating to causing miscarriage, acts endangering the life of an unborn child, and causing death of a quick unborn child. These provisions correspond to Section 312 to Section 316 of the Indian Penal Code, with largely similar structure and intent, but are recodified to maintain clarity and coherence in the new criminal law framework, that is Bharatiya Nyaya Samhita. Section 88 of the Bharatiya Nyaya Samhita criminalizes voluntarily causing miscarriage, whether committed by any person or by the woman herself, unless done in good faith to save her life, with enhanced punishment when the woman is quick with the child. Section 89 covers aggravated situation where miscarriage is caused without the woman's consent, making it punishable with imprisonment up to 10 years or life. Section 90 deals with cases where an act intended to cause miscarriage results in the death of the pregnant woman, with stricter consequences when her consent is absent. Section 91 penalizes acts done before birth with the intention of preventing a child from being born alive or causing its death after birth, unless protected by good faith to save the mother. Finally, Section 92 addresses causing the death of a quick unborn child by an act amounting to culpable homicide. Together, these sections safeguard both maternal health and fetal life, while recognizing medical exception under the Medical Termination of Pregnancy Act. Section 88 of the Bharatiya Nyaya Samhita that defines causing miscarriage. Whoever voluntarily causes a woman with child to miscarry shall, if such miscarriage be not caused in good faith for the purpose of saving the life of the woman, be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. And if the woman be quick with child, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Explanation appended to this section shows a woman who causes herself to miscarry is within the meaning of this section. Section 88 of the Bharatiya Nyaya Samhita corresponds to Section 312 of the Indian Penal Code. Section 88 of the Bharatiya Nyaya Samhita deals with causing a miscarriage with the consent of the victim, while the next section deals with those cases where consent is lacking. The very ingredient of this section is 1. There must be voluntarily causing a woman with child to miscarry. 2. Such miscarriage should not have been caused in good faith for saving the life of the pregnant woman. The first ingredient includes the pregnant woman herself or any other person. A woman with child means a pregnant woman. Quickening means perception by the mother of the movement of the fetus in her womb. It is immaterial whether pregnancy is so advanced that fetus is moving in the womb of the pregnant woman for the application of the section. In Madras case, where a woman was acquitted on a charge of causing herself to miscarry on the ground that she had only been pregnant for 1 month and that there was nothing which could be called fetus or child, it was held that acquittal was bad in law. Miscarriage means premature expulsion of the child or fetus from the mother's womb before the completion of natural gestation period. It is always artificial, while delivery is natural, though in case of delivery, also sometime operation or other means are employed. Quick with child literally means having conceived, but it connotes the peculiar perception felt by a pregnant woman when the fetus in the womb begins to move, which generally occurs after fourth or fifth month of the pregnancy. The punishment, not if the termination, that is miscarriage, was not caused in good faith. If such miscarriage is not caused in good faith for the purpose of saving the life of the woman, the offender shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. The quick with child means if the woman be quick with child, the offender shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Section 89 of the Bharatiya Nyaya Samhita that talks about the causing miscarriage without woman's consent. That is, whoever, section 89 runs as whoever commits the offense under section 88 without the consent of the woman, whether the woman is quick with child or not, shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Section 89 of the Bharatiya Nyaya Samhita corresponds to section 313 of the Indian Penal Code. Section 89 of the Bharatiya Nyaya Samhita, under this section, miscarriage is caused without obtaining the consent of the woman. Hence, only the person who causes the abortion is punished and the woman is not punished. While in section 88 of the Bharatiya Nyaya Samhita, the woman who causes herself to miscarry is also punished. The ingredient of this section is a person commits the offense of voluntarily causing a woman with child to miscarry is defined in section 88, and he does so, that is, the accused person does so without the consent of the woman. Such person who has committed an offense under this section shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. However, there are certain situations when abortion may be permissible under the special law, that is, Medical Termination of Pregnancy Act 1971, popularly known as the MTPA Act. It would not be an offense if it is caused, provided a. to preserve the life or physical or mental well-being of the mother, that is pregnant woman. If it is caused to prevent birth of a child conceived as a result of rape on a woman. If miscarriage is caused where there is a possibility of birth of a child with some serious deformity, which may be physical, mental, or genetic abnormality. In these cases, if the miscarriage has taken place, then the accused will not be liable. In a famous case in Suchitra Srivastava versus Chandigarh administration, the Supreme Court held that exceptions for abortion has been made in case of mentally ill women, and it has no application to a woman who is mentally retarded and there is no congenital defect in the child in her womb. Section 90 of the Bharatiya Nyaya Samhita that talks about the death caused by an act done with intent to cause miscarriage. Subsection 1 of section 90 of the Bharatiya Nyaya Samhita provides that whoever with intent to cause the miscarriage of a woman with child does any act which causes the death of such woman shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Subsection 2 provides where the act referred to in subsection 1 is done without the consent of the woman shall be punishable either with imprisonment for life or with imprisonment is specified in said subsection. Explanation to this section provides It is not essential to this offense that the offender should know that the act is likely to cause death. The section 90 of the Bharatiya Nyaya Samhita correspond to section 314 of the Indian Penal Code 1872. Commenting on this section, it can be said that section 890 punishes the person who has intent to cause miscarriage of a woman and while doing so causes the death of such woman. The ingredient of this section, that is section 90 subsection 1, to be prosecuted under this section, the prosecution has to establish the following ingredient that must coexist. They are: number 1, the woman was pregnant with child. Number 2, the accused committed an act with intent to cause the miscarriage. And number 3, such act caused the death of the woman. It is not essential for this offense that the offender should know that the act is likely to cause death of the woman. The punishment provided under subsection 1 of section 90 state that the offender shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Then further subsection 2 of section 90 provides, without consent, if such act was done without the consent of the woman, the offender shall be punished either with imprisonment for life or with imprisonment specified in subsection 1. In case of Surendra Chauhan versus State of Madhya Pradesh, the accused had illicit relation with the deceased, and when she became pregnant, he took her to a clinic with intent to cause abortion. The woman died during the process as the doctor was not competent to terminate pregnancy, nor was his clinic approved by the government as required under section 4 of the Medical Termination of Pregnancy Act 1971. The High Court held that the accused was, as well as the doctor, liable under section 314, read with section 34 of the Indian Penal Code, that is now section 90, read with section 3, subsection 5 of the Bharatiya Nyaya Samhita 2023. Then section 91 of the Bharatiya Nyaya Samhita that provides act done with intent to prevent child being born alive or to cause to die after birth. Section 91 of the Bharatiya Nyaya Samhita provides that whoever before the birth of any child does any act with the intention of thereby preventing that child from being born alive or causing it to die after its birth, and does by such act prevent that child from being born alive or causes it to die after its birth, shall, if such act be not caused in good faith for the purpose of saving the life of the mother, be punished with imprisonment of either description for a term which may extend to 10 years or with fine or with both. Section 91 of the Bharatiya Nyaya Samhita corresponds to section 315 of the Indian Penal Code 1872. Section 91 of the Bharatiya Nyaya Samhita covers the acts which result in the destruction of the child's life, whether before or after its birth. The very ingredient of section 91 provides that a person before the birth of any child does any act with the intention of preventing that child from being born alive, or he does an act with the intention of causing that child to die after its birth. Such act prevents that child from being born alive or causes it to die after its birth. The third ingredient is the act is not caused in good faith for the purpose of saving the life of the mother. Such person is an offender under this section and is liable to be punished with imprisonment of either description for a term which may extend to 10 years or with fine or with both. Section 92 of the Bharatiya Nyaya Samhita that provides the causing death of quick unborn child by act amounting to culpable homicide. Section 92 of the Bharatiya Nyaya Samhita 2023 that provides whoever does any act under such circumstances that if he thereby caused death, he would be guilty of culpable homicide, and does by such act cause the death of a quick unborn child, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Illustration appended to this section 92 of the Bharatiya Nyaya Samhita provides that illustration A. Knowing that he is likely to cause the death of a pregnant woman, that is culpable homicide, the woman is injured but does not die without the death to an unborn quick child with which she is pregnant is thereby caused. A is guilty of the offense defined in this section. I repeat, A knowing that he is likely to cause the death of a pregnant woman, that is causing of death will be a culpable homicide. The woman is injured but does not or but won't dies without the death of an unborn quick child with which she is pregnant is thereby caused. A is guilty of the offense defined in this section. Section 92 of the Bharatiya Nyaya Samhita corresponds to section 316 of the Indian Penal Code. Section 92 deals with the offense of causing death of unborn children when they are in the advanced stage of pregnancy, beyond the stage of quickening, that is, when death is caused after the quickening but before the birth of the child. The principle laid down in section 102 is applied here. The offense of culpable homicide applicable to a living person, that is the victim, would be applied in this case where the sufferer is a quick unborn child whose death is caused by any act or omission of the nature which would have caused the death of a living person as mentioned above. The offender under this section shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. In Murugan versus State, the accused physically assaulted his 20-week pregnant woman, that is pregnant wife, thereby causing death of fetus. The medical evidence showed the fetus starts taking shape after about 12 weeks of conception. The accused was therefore convicted for the offense of causing death of a quick unborn child under section 316 of the Indian Penal Code 1872, and that is now section 92 of the Bharatiya Nyaya Samhita. Thank you.